I'm David Rabinovitz. We do this every Friday. Thanks for joining us here on Pro Cannabis Media in the Green Rush. I'm joined by my co-host, Kurt Dalton, and by our exceptionally special guest that we're thrilled to have today, Professor Robert Mikos from Vanderbilt Law. This is basically for us a very special show. We're going to take a really deep dive into whether or not interstate commerce in cannabis is going to be allowed, or how it could be allowed, what the ramifications are. And I think we have the best lineup of industry guests that we have ever had on this show. So with that, I'm going to flip it to Kurt, and then we're going to let the professor introduce himself and start the discussion going.
Thanks, David. Welcome, Professor. For those folks just tuning in and kind of seeing some of the links out there, we did an article based on Professor Mikos's paper and got a tremendous amount of comments and shares. I think it's over 1,400 shares. Basically saying that interstate commerce, I'll let the professor correct me, may actually be legal for the cannabis and marijuana plant based on the dormancy commerce clause in the Constitution. So before you even get into the paper, Professor, what was the inspiration to kind of, one night at dinner, go down the road to the left and say, hey, I think marijuana interstate commerce is legal. Let me pull out some of those books in the library. How did it start? What was the germination of this paper?
It's a great question, but first, thanks both to you, Kurt, and to you, David, for having me. Happy to be here this Friday afternoon. In large part, I saw what the states were doing, and I noticed that they've got these weird bubble-like markets. So Massachusetts will have its own cannabis market, its own cultivators and processors and retailers. And then, across the way, you've got Connecticut with its own set of suppliers, New York, New Jersey, Colorado, go down the list. And there's no cannabis moving across state lines, and actually very limited investment across state lines. And I think one day that just struck me as so odd in comparison to every other market we have out there. You go to the grocery store now, you might be in Florida, but you'll see avocados from California. Tennessee, we're a big auto state, but we'll see autos made in Ohio. So normally we don't see this sort of segmentation or bubble-like markets in the state. We normally see that. And I know there's a constitutional doctrine out there, the Dormant Commerce Clause, that's designed to stop that. It's actually designed to promote free trade and the development of national markets. So I started to dig into, why isn't that Dormant Commerce Clause operating here? Why is it that the states are allowed, and every state that's legalized cannabis right now bans the importation of out-of-state product, and a lot of them ban outside investors, non-residents, from investing in local industry. So I started asking, how is it that states are getting away with this? And I never got a satisfactory answer. One thing led to another. You keep digging, you keep digging, you keep digging, and you discover, hey, maybe this is unsustainable. Maybe the states can't keep doing this. Maybe what they're doing, actually, they can legalize cannabis, but they can't say, we're going to legalize it only for insiders. You really got to treat those insiders and outsiders alike. And that's sort of where one thing led to another. It's just noticing that incongruity between cannabis and every other market that's out there.
So is this, I guess we'd say that the dormant commerce clause is the smoking gun of this debate. Does that include a Schedule I drug when that was put in? The federal government's CSA, Controlled Substance Act, has it as a Schedule I drug, cannabis, unfortunately. There's no precursor or excluding when it comes to a commerce clause if it's a illegal federal drug?
It's a great question. So in a nutshell, that Dormant Commerce Clause, it is a default free trade principle. So this is the states, you can't unduly burden interstate commerce. But the question is, well, what if the federal government has made that commerce illegal?
Yeah.
And clearly Congress has done that. And I think the states, when they adopted all these bans on imports and exports and out-of-state investment, I think they kind of assumed that, hey, maybe Congress has turned off this principle. Because as I mentioned, The Dormant Commerce Clause is really a default constitutional principle. It's not explicitly stated in the Constitution. The court has just looked at that and said, we assume that Congress wants to promote free trade. But if it tells us otherwise, it can suspend this Dormant Commerce Clause. And I think the states all assumed, hey, Congress banned this. You've got no federal right to sell it. So we can do with it as we please. We can legalize, say Massachusetts, we're going to let locals grow it and sell it. But if you're not a stater, you're out of luck. And I think everybody kind of bought into that without kind of testing that assumption. And what I've done in a couple of papers is really one called Interstate Commerce and Cannabis. It's really testing that assumption and kind of picking it apart. To the federal government's perspective, from Congress's perspective, it doesn't care where the cannabis comes from. It's not like it says, hey, you grow this stuff in Boston and sell it to somebody in Boston and we don't care. That's legal. But the moment you take it outside of Boston and take it into Connecticut or some other state, we care about it. Congress has no reason to care where cannabis comes from. Its objective in the Controlled Substances Act was to quash this market entirely, to wipe it out. So I think once you recognize that Congress doesn't care whether you're selling across state lines or entirely within a state, this idea that Congress has somehow permitted the states to discriminate against outsiders starts to fall apart. And that's why I think today, all of these barriers states have erected to interstate commerce and cannabis, they are subject to challenge under this Dormant Commerce Clause principle, notwithstanding that federal ban.
Would you say, I mean, this is the meat of it, you brought up the word test it. Spoke to a few lawyers today. What does that look like? I mean, we have a lot of stories about a guy named Dale Jackson from Georgia who has an autistic son, and he went across state lines, invited the press, bought some cannabis oil, brought it over, asked the press and police to follow him, arrest him if you want. Is that kind of what we're looking at for a test, that a medical license holder or a recreational license holder, say in Massachusetts, which will be a good lead in for another guest we have coming on, goes to California, orders from California, or ships it, says, here's my package, I'm putting it in the mail, or I'm driving it to New York or California, have the press follow them, please arrest me, my lawyer's with me. What does a test of this look like in reality?
Yeah, so that's one possibility. And that's a very sympathetic test. So if you want to push a legal theory like this, you want to find the most sympathetic case you can. And that might be a case of that. That's a patient, though, sort of just possessing it and bringing it across state lines. Another possibility, and there are actually several legal cases out there right now, test cases, including one in neighboring Maine. You could be an outsider, you want to invest in the cannabis market in another state. That state says, can't do that. We only allow residents to own our shops. Well, you could sue the state and ask the court for an injunction blocking that residency requirement for a cannabis license. And in fact, there have been such lawsuits filed in Maine, Missouri, Oklahoma, Michigan, and I believe Washington State as well. We have decisions striking down those residency requirements in at least 3 of those states. The federal court in Maine said, Maine, you can't do this. You can't limit your market just to residents. It violates the Dormant Commerce Clause. Same answer, just at the preliminary injunction stage in Michigan, same answer in Missouri. Oklahoma had a weird reason for getting rid of the case. And so those are test cases, and they're coming out for the way I've predicted. The courts are saying this violates the Dormant Commerce Clause. The next step would be somebody pushing to sell across state lines. That's a harder test because I think for a variety of reasons, federal judges might be a little bit leery about saying, state of Massachusetts, you have to let in Oregon product. The optics of that are a little bit different. The fashioning, the remedy is a little bit different. but yeah, lots of different ways that you could test these state restrictions on bringing product across state lines or investing across state lines.
So if somebody were to decide to challenge this, a licensee wanted to challenge this particular issue, would they be better to go to federal court or state court? Doesn't matter.
Oddly enough, you're probably better going to federal court. And each of these cases has actually been, that I mentioned, has been litigated in the federal court. Might seem strange because it's a federal that bans this, but it's also a federal constitutional principle that you would be invoking. And you might worry that a state judge, that forum selection is always an important issue in litigation. You might worry that a state judge is going to sympathize with state lawmakers and say, hey, they wanted to keep all the benefits of legalization and reserve those just for state residents. They didn't want outsiders making a profit off this. They didn't want outsiders taking some of the jobs. So a state judge might be elected, might be reluctant to invalidate a state restriction in the state commerce. I think a federal judge may not be so hesitant.
Interesting.
In a couple scenarios David and I talked about earlier, one was I see this being a 3 to 5 year process. If you're going to invite, say, the press or the police to join you, you're going to ship it or drive it over a state line, arrest me, you're going to need a legal fund. You're going to get federally indicted at the time. It's going to take 3 to 5 years of appeals. And if you win, you may be the person, maybe at the Supreme Court, that gets this done. David thinks it would all be a much quicker process, kind of pre-trial motions. What do you think how would it break down on timing and money?
Yeah, it does take time. So this is all assuming no federal legalization, because I think that'll speed the process up dramatically. But it will take time because like that main lawsuit is just now going to the federal appeals court. One of the parties, the party challenging the residency requirement, won in the district court. The suit was started more than a year ago, I think, at this point. Just now getting to the appeals court. The appeals court has agreed we should stay the injunction, which means you get to keep your residency requirement, Maine, until we can rule on this issue and decide whether or not this is unconstitutional.
Really?
Yeah, so 2 to 3 years is probably the amount of time it would take to get kind of a higher court to rule on it. Maybe not the Supreme Court, but at least a federal appeals court to rule on it. You can get those preliminary injunctions and so on, and maybe that's helpful. But what you really want is sort of a precedent from an appellate court sort of validating this position. I think that sends a much stronger signal. And you wouldn't necessarily, to sort of Kurt's scenario where you've got a patient who says, arrest me, you wouldn't necessarily have to do that. There's a famous old Supreme Court case, not that old, but Gonzalez versus Raich. The Supreme Court said, hey, Congress, you can criminalize intrastate activity, not just interstate activity. That was actually brought by a couple of women who were participating in Prop 215 out there. They asked the court for a declaration, a declaratory judgment, basically a statement from the court saying to the Attorney General of the United States, the application of the Controlled Substances Act to purely intrastate activities is unconstitutional. It took years and years to get to the Supreme Court. The Supreme Court said no, ultimately, but you don't necessarily have to be arrested to bring one of these actions. You could seek a declaratory judgment as long as you had a reasonable chance that you're going to be facing some sort of prosecution, probably from the state, because you want to challenge state law, not federal. But if you had that reasonable probability, you could seek a declaratory judgment, an injunction to block the state from discriminating against you because you're an outsider.
My recollection was that it was the Butte County sheriffs and the DEA that raided Angel Rach's home, I thought in 2002. That sound right?
I think that's about right.
Yeah.
So that's what sort of triggered it. And so they, of course, they had an interest going forward. They wanted to know, hey, can we recreate this grow? And there were a couple of other patients that glommed onto that. And they sought that declaratory judgment. But Supreme Court didn't get around to ruling on that, giving a final ruling until 2005. So a 3-year time period. If you want to get all the way to the Supreme Court, that may be how long it takes.
Right, that actually, from my limited understanding, I'm not an attorney, but to get up to the Supreme Court, 3 years is kind of quick.
Yeah, unless it's something involving some emergency action, or presidential action, that they're going to take their time with these things. They want the lower courts to
So if a licensee would need to initiate this, right? Because I could see two ways this could happen. One is the licensee says, I'm going to import it. And we'll talk about that on one of our panels, because I've got this great scheme. I got my hat, my dark glasses, and tomorrow we're going to start importing weed from the West Coast.
There he is. All of the media follow you.
Here we are. So it seems to me there's two ways to initiate this. One way is you bring it in and wait for the feds to do something, and the other one is you say, I want to do this, and I'm suing you to get a declaration that says you can't stop me from doing it. What would? Oh, go ahead.
Yeah, that's correct. I don't know if it's the feds you want to worry about. I think, again, to my mind, that the big barrier to importation and exportation is the states. Yeah, Massachusetts says don't import the stuff. Colorado says don't import the stuff.
Yep.
So you really want to challenge state law. So you want to get some state. You would want to be arrested if you would ever want that to happen. You want to be arrested by the state authority and then challenge their law. Their ban on importation. Say, hey, this violates the Dormant Commerce Clause. You're letting all these other people grow and sell the drug. You're discriminating against me because I grew it out of state, and that's unconstitutional. You'd want to do it that way, but the alternative and the safer route is to seek that declaration. And that's kind of what these out-of-state companies or investors that want to own cannabis businesses in other states, they're in a safer posture there. I think that's why those lawsuits have been brought first, because they can go to the state and say, we're just applying for a license. The state says, you can't, you're an outsider, you're not a resident. And then you can sue the state and say, this violates the Constitution, without risking criminal penalties.
So Kurt, take that saw blade out of the banana nut bread you were making for me. I don't think I'm going to need it. We'll challenge it in advance.
Yeah, we should do this all in advance before getting arrested. We should get all the paperwork ready before you get Logan by the airport.
And don't bake any weed into that loaf.
We've always, the situations we're throwing at you, Professor, have always been licensees. For those people who don't have a license, an illicit grower takes a minivan across country from Emerald Triangle to New York City, boom, he's arrested. He should not just say, I invoke the Dormant Commerce Clause of the Constitution. I invoke the door. That's not going to cut it, right?
That's right. So in that instance, the state would say, with the Dormant Commerce Clause at its core, it bars geographic discrimination. So it says, New York State, you can't treat outside business people different than inside business people. You can't give those insiders a regulatory leg up. But all of the states that have legalized cannabis, they continue to ban the black market, whether it's the in-state black market or the out-of-state black market. So they'd say to that Emerald or Emerald Triangle grower, hey, we're treating you just like we would treat the guy in-state that's doing this without a license. And so there'd be no Dormant Commerce Clause challenge to bring there.
Wanted to clarify that for some of our viewers.
Yeah.
Who pull out their cell phone and show the police our show as we're getting arrested.
Yeah, just as a disclaimer, none of this is legal advice, either for you or for your viewers, of course. But these are my sort of prognostications about how the law would shake out here.
So I understand we've got a lot of people in the chat room. Thanks for joining us. It's 4:20 on the East Coast, and most of you know what that means. Even though Jimmy's not with us today, he's actually in the YouTube chat room monitoring and texting me with questions that people have. So we're going to take our standard break. We're going to be right back. Don't go away. Enjoy the 4:20 break, and we'll see you back in a few minutes here in the Green Rush.